All right, folks, this is take two. If you somehow managed to join us at 8 o'clock, sorry about that. This was an unannounced live stream. Thank God, because we had a huge screw up right at the beginning. It turned out I hadn't had my Rumble configured properly. And this is how this goes when you're using a new medium to get your videos out. And this is actually the first stream we have ever done. We are simultaneously live on YouTube and on Rumble, which is really exciting. So it's a little bit of a bumpy ride as we go. And in fact, the stream we had a couple of nights ago with Anna Timmer and Amber Harris, I thought was going just great the entire time, except we didn't have anybody in chat. And then it turns out that the problem was Rumble does not show comments from the chat in StreamYard, and I didn't have a separate video opening showing my live Rumble feed where I could see those chats. So if people were chatting during the course of the stream, we missed them all. And unfortunately, Rumble doesn't archive the chats the way YouTube does. With YouTube, we do a live stream, and then there's a time delay of like I think 12 hours or something, and then the comments that were people are posting in the chat as the live stream is going will show up, and that didn't happen. It doesn't happen on Rumble, so we lost out there. So we're trying to kind of get our bearings here on multi-streaming, but yeah, this is for the first time we're streaming on YouTube and Rumble. And the exciting thing about YouTube is that we got a channel strike last Monday, which meant we were not allowed to post videos for a week, and it meant if we got 2 more strikes, they would ban us from ever posting on YouTube again. And that's for talking about things like the stuff we're going to be talking about tonight, this election integrity lawsuit. And that's I think tonight's stream is going to be very clearly within the purview of what can be talked about, although who knows with YouTube. But pleasantly surprisingly, they actually reinstated our YouTube channel. We appealed the strike, and they sided with us. So when the strike was removed, the YouTube channel was reinstated, and we don't have a channel strike on our record. And that's all well and good. So we're going to just get right into it, folks. I want to talk tonight about this big new lawsuit that's been filed against Jocelyn Benson from a group called the Public Interest Legal Foundation. It's a federal lawsuit alleging that Jocelyn Benson has repeatedly and continuously refused to purge dead voters from the voter rolls. And it was just filed 4 days ago. We touched on it a little bit in the show with Amber and Anna 2 nights ago. I strongly encourage you folks, watch the entire stream. Lots of great discussion on a number of topics, current events, grassroots leadership, all the great things that they're doing in Oakland and Kent counties. Worth checking out if you haven't already. But I did want to do a deeper dive on this lawsuit. I heard Tucker Carlson covered this, and I try to watch Tucker whenever I can, but sometimes I'm traveling and doing events and I miss him. But someone told me Tucker actually covered this lawsuit. So it's got some traction out there, at least in terms of public interest. But what we're going to do, we're going to read through the lawsuit. It's not too long. It's 20 pages, double spaced. And we will talk about their arguments, talk about their facts, or their alleged facts, and talk about what potential this has moving forward. So, let's get right to it. I'm going to just pull up the document here. Let's see, which looks better now. That's not good. That's better. Okay, here we go. Oh, wait, that's even better. U.S. District Court for the Western District of Michigan. Public Interest Legal Foundation plaintiff v. Jocelyn Benson in her official capacity as Michigan Secretary of State defendant. Plaintiff, Public Interest Legal Foundation, by and through its attorneys, brings this action for violations of Section 8 of the National Voter Registration Act against Jocelyn Benson in her official capacity as Michigan Secretary of State. So this is in federal court. That's important. This is not in a state court. Why is that important? Because depending on who you get as a judge, things don't look great in the State Court of Appeals right now. They don't look great at the state Supreme Court right now. Federal bench might be better. And this is in the Western District of Michigan, I believe. Is that what it said? Western District of Michigan, yeah. Which I think includes Lansing. So jurisdiction and venue. I don't think there's much we need to really talk about here. It's a federal lawsuit. It's a suit relating to U.S. law. They're also seeking injunctive and declaratory relief against the National Voting Rights Act. Interesting. Venue's proper because the defendant, Jocelyn Benson, resides in this district. So yeah, that's what they're saying, is that she's in Lansing, so we're suing you in Lansing. The parties. Public Interest Legal Foundation is a nonpartisan, nonprofit, public interest organization incorporated and based in Indianapolis, Indiana. The foundation seeks to promote. Oh, which one am I? I'm looking in the wrong direction here. Let me do this. I'm going to switch my screens around so it looks kind of like I'm actually looking there. I thought it was better. Now I'm looking at the text on my screen. Anyway, the foundation seeks to promote the integrity of elections in Michigan and other jurisdictions nationwide through research, education, remedial programs, and litigation. The foundation has dedicated significant time and resources to ensure that the voter rolls in the state of Michigan do not contain ineligible registrants. The foundation communicates with election officials about problems or defects found in list maintenance practices and about ways to improve those practices. The foundation relies on accurate voter rolls to conduct analyses and to educate the public in Michigan and across the nation about the integrity of their elections. The foundation's analysis of Michigan's voter roll and verifiable death records reveals that, as of August 2021, 25,975 potentially deceased registrants in Michigan are on Michigan's voter rolls. Of those, 23,663 registrants have been dead for 5 years or more, 17,479 registrants have been dead for at least 10 years, and 3,956 registrants have been dead for at least 20 years. Defendant Jocelyn Benson is the Michigan Secretary of State. Secretary Benson is the Chief Election Officer of Michigan for the purposes of the National Voting Rights Act, and Secretary Benson is sued in her official capacity. Because Benson does not maintain accurate voter rolls, the foundation must spend more time and resources evaluating Michigan's rolls and attempting to correct the problems. The foundation has spent many thousands of dollars reviewing Michigan's election procedures and documented failures to maintain an accurate and correct voter roll as required by the National Voting Rights Act. Defendant's unlawful list maintenance program has forced the foundation to incur substantial costs comparing Michigan's voter rolls to the Social Security Death Index, various commercial databases, and other sources in order to identify deceased registrants. Defendants' violations of the National Voting Rights Act have harmed and continue to harm and frustrate the foundation's purpose of protecting the integrity of the electoral process, ensuring that accurate and current voter registration rolls are maintained, and educating the public about the same. The foundation's expenditure of significant time and money in Michigan, seeking to rectify defendants' failures to clean up the voter rolls by removing the surfeit of deceased registrants from such rolls, has also forced the foundation to divert its limited resources from other states with similar issues. All of these harms confer standing upon the foundation to assert the claim raised in this case. Okay. This is an interesting argument they are making, and I predict this is the very first thing the Secretary of State fires back at, is the question of what gives you the standing to sue us. You're an organization based, I think they said, in Illinois or Indiana, and what you're essentially claiming is we haven't done our jobs and it's caused you to have to spend more money. And that's an open question whether or not that's valid or not. Ultimately, it's going to be a question for a judge. It's a question for a judge whether or not this constitutes sufficient standing for remedy. And by the way, folks, I'm not an attorney. I just play one at the Capitol. I've done years and years of legislative work for members of Congress and for state lawmakers, so that involves a lot of legal analysis. I've incidentally also been a successful pro se defendant in a jury trial. I got a noise violation and demanded a trial by jury and actually won, which is a long and very interesting story of its own. I'm not going to tell it tonight, but point being, I've been in a courtroom a couple of times. I've worked with legislation. I've worked with law, so I might not be an attorney. So take my word for it or don't. But here's what's going to happen. Benson's going to need to file a motion to dismiss to try to get out of the lawsuit as early as possible. The way lawsuits work is, number one, if you can prove that they have the party that's suing you, i.e. the PILF, has not established a cognizable legal claim, or they haven't pled facts to show that they have a claim, or they don't have standing for a claim, then they can get the suit dismissed before it ever gets anywhere, which is what they want. So that's what they're going to go for. Now, they're going to allege, we're going to read through this, they're going to allege various facts. They're going to say Benson did this, and Benson did this, and Benson didn't do this. And Benson can dispute all of those, but in litigation, questions of fact are for a jury. They're not to be ruled out before a jury has had a chance to hear the facts and to make a factual determination. So what Benson's going to want to do is to get this dismissed, not because of the facts, but because of the law, either saying that their argument is so weak that there's nothing to address here, or they don't have standing, or there's no way that we can remedy this. These are the kinds of arguments you make to try to dismiss a lawsuit. And whether or not they have merit and whether or not the judge agrees they have merit are two different questions. But that's what they're going to try to do. But essentially, I mean, this is an interesting argument that we've been forced to spend more money as an organization in other states because Michigan's problems are so bad that we're spending money here. I don't know a judge might necessarily buy that. Rescue Michigan Coalition is a political organization. These guys are a nonprofit organization. Now, I can tell you, sometimes failure brings money into your organization. If there's I'll give you a great example. In 2013, the left was on the march trying to do everything to limit gun rights. It was after the, which was it? I think it was the, what was that one? Sandy Hook shooting, I think it was. And they were all in on passing all kinds of gun rights restrictions. What happened to the gun rights groups? They all made tons and tons and tons and tons of money from people that wanted to fight back against the radical left trying to ban guns. That can happen in policy. Now, I'm not saying the judge is going to take that position, but potentially they could. So these are the issues that Benson's going to try to raise. So that's kind of where that is. We'll talk more about this after we read through more of the lawsuit. But now let's get into the fun stuff. Statement of facts and law. Section 8 of the National Voting Rights Act requires Michigan to conduct a general program that makes a reasonable effort to remove the names of ineligible voters from the official lists of eligible voters by reason of, inter alia, the death of the registrant. Section 8 of the National Voting Rights Act also requires that Michigan shall. You notice shall is not inside the quotation mark, but whatever the word is, shall means you have to, you must, you have a legal duty to do what this is, to complete not later than 90 days prior to the date of the primary or general election for federal office, any program the purpose of which is to systematically remove the names of ineligible voters from the official lists of eligible voters. Although Section 8 of the National Voting Rights Act generally restricts states from removing ineligible registrants from the voter rolls within 90 days of a primary or general election, Congress permitted the removal of residents who have died. So has Michigan. Notice the word permitted, not required. But we'll see where this goes, because I think we'll see in this case, they're not just saying they didn't remove people after the 90 days went by. They didn't remove people for an extended period. So here we go. So they say registrants who have died may be removed at any time. See also, and then there's a reference here where, and this is from the Justice Department. This is, let's see what this says here. Well, when it says available at, this has to be a current document. When I saw 1993, I thought maybe this is old, but no. If it's available at this page online, they're citing it to the court. That means this is an active page, and they say this 90-day deadline does not, however, preclude removal of names at the request of the registrant, removal due to the death of the registrant, removal due to criminal conviction, or mental incapacity of the registrant as provided by state law, nor does the deadline preclude correction of a registrant's information. And again, notice they're not arguing that they had a duty to remove every single dead voter. They're saying they could. The defendant is the chief election official of Michigan and is responsible for coordination of Michigan's responsibilities under the National Voting Rights Act. Congress intended for the chief election official to be responsible for implementing state's function under the National Voting Rights Act. Although a state may assign certain tasks associated with the voter registration process to different officials in the state, the chief election official remains responsible at all times, pursuant to federal law, and they're emphasizing federal because it's a federal case, for coordinating and implementing the NVRA's myriad legal mandates. According to the U.S. Department of Justice, the chief state election official for NVRA purposes is a proper defendant in any statewide NVRA jurisdiction. Defendant's responsibility for coordinating with local election officials to ensure the removal of deceased voters is a core component of her National Voting Rights Act statutory obligation. It is also mandated by the federal Help America Vote Act. For example, Michigan's state plan under HAVA states that in order to provide local election officials with the tools to comply with the National Voter Registration Act, I'm sorry, I was saying National Voting Rights Act. It's National Voter Registration Act. Same difference. The state of Michigan enhanced the qualified voter file to automate the cancellation process. The QVF will automatically forward lists of registered voters subject to cancellation to each election official. Okay. Now, notice what this does not say. It says they have a responsibility, but it's not specific. It says it's mandated, but it's not specific. But then it gives an example that states, in order to provide local election with the tools the state of Michigan enhanced to automate the cancellation. This is not saying, for example, she has to do this, she has to do that. They're saying Michigan state plan under HAVA, which how legally binding that is unclear. And I have a feeling it's not, because often these plans are not binding. They're not requirements. Otherwise, they wouldn't be called plans. It states, in order to provide local officials with the tools the state of Michigan enhanced to automate the cancellation, which just saying this is something that was done. This was done to automate the cancellation process. And it says, the QVF, the qualified voter file. This is Jocelyn Benson's voter file, the entire state of Michigan's voter file. It will automatically forward list of registered voters subject to cancellation to each election official. Okay, but that's not the issue that we're talking about. The issue we're talking about is the statewide voter file, I think. But let's read on. Let's see where they're taking this. Pursuant to Michigan law, defendants shall direct and supervise the establishment and maintenance of a statewide qualified voter file. Yep. Specifically, the Michigan law requires defendant to develop and utilize a process by which information obtained through the USSSA, Social Security Administration, death master file that is used to cancel an operator's or chauffeur's license of a deceased registrant of the state is also used at least once a month to update the qualified voter file to cancel the voter registration of any elector determined to be deceased. There it is. This is what we were looking for. They are required by Michigan law. And this is MCL 168.50904. Secretary of State shall make the canceled voter registration information under this subsection available to the clerk of each city or township to assist with the clerk's obligations under Section 510. Upon information and belief. Now, what this means is this is what we're alleging. And what they hope is if they get through any pretrial dismissals, this will go to discovery. And that is where they get to find out, what did Benson do? That's when they start getting to ask, turn over all of your relevant emails relating to maintenance of the qualified voter file. And if this lawsuit gets even to that stage, it is revelatory. Because even if the lawsuit ultimately loses, going through discovery can be huge. As a perfect example, Project Veritas, that recently got politically raided by the FBI this week, is suing the New York Times for defamation. They got past their pretrial dismissals. They are now in the process of deposing New York Times reporters, editors, getting emails, getting confidential documents, everything that they need to be able to prove their case. That comes in the discovery phase. Anyway, upon information and belief, meaning this is what we think happens. Jocelyn Benson, and not any local election official, is responsible for reviewing and acting upon Social Security Death Index information. In response to a complaint filed by the Foundation against the City of Detroit, interesting, election officials regarding deceased registrants, the Foundation identified the defendants attached to a declaration and email from Rachel Clone, Data Analytics and Support Manager at the Michigan Department of State Bureau of Elections. A true and correct copy of the declaration and relevant attachment is included herein as Exhibit 2. So what is this saying exactly? In response to a complaint filed by the Foundation. Okay, so what happened is they sued the city of Detroit, and the defendants attached this declaration. To answer your question regarding the Social Security Death Index and its role in voter registration file maintenance, I can confirm that the Michigan Secretary of State receives this data through a comparison process updates records as deceased within the driver and state personal ID file through an automated process. This information interfaces with the qualified voter file in order to cancel corresponding voter registrations. So what happened was this group previously sued Detroit about this. And Detroit said, it's the Secretary of State that's responsible for these things. And they just pull their voter rolls from the SOS. That's what they're saying. City of Detroit election officials also stated that they provided the state of Michigan with the potentially deceased registrant data provided by the foundation. According to the City of Detroit election officials, the state discovered that in many cases, discrepancies between the information contained in the state and the Social Security death index and in the qualified voter file has made it difficult to confirm the deaths of the voters at issue. However, the state is continuing its investigation and is canceling voters as deceased as it deems appropriate. And again, they quote Michigan law, at least once a month, the county clerk shall forward a list of the last known address and birth date to all persons who have died within the county. The city or township clerk shall compare this list with the registration records and cancel the registration of all deceased electors. According to Michigan law, Benson shall notify each clerk of the following information regarding residents or former residents of the clerk's city or township. Death notices received by the Secretary of State. Additionally, Michigan law provides that local election officials may conduct a house-to-house canvass or use such other means of checking the correctness of registration records as may seem expedient. The Michigan Elections Officials Manual is a document that is designed to serve as a lasting information resource on election-related matters. Introduction, Michigan Election Officials Manual, available at. This is a good link they have here. I would encourage you all to bookmark it. This is the Michigan Election Officers Manual. Interesting stuff. We might have to read through that on a stream one of these days. Pursuant to the Michigan Election Officials Manual, local election officials are authorized to cancel registration records when, for example, the clerk receives or obtains information that the voter has died. For example, sources, QVF, inbox notification, county clerk, death notices published in newspaper, firsthand personal knowledge. And again, they give the link here. Now, starting a new section here, but what they've laid out in this section is that Jocelyn Benson has an obligation to keep the voter rolls clean. This is what Michigan does to remove dead people. The county officials can remove them from the rolls. The state is supposed to be checking with the Social Security Administration to remove them from the rolls. That's how that all works. All right, now they get to the arguments. Michigan's list maintenance programs and activities are unreasonable. And I say arguments. They're still bringing in facts. As explained by the U.S. Department of Justice, the question of whether the general program of list maintenance as chief election official undertakes, in fact, amounts to a reasonable effort to remove ineligible voters under Section 8 of the National Voter Registration Act goes beyond the simple existence of state laws and procedures to include consideration of the actual efforts undertaken pursuant to those laws and practices. So the legal burden is a reasonable effort, and that's why they're arguing that this is unreasonable, what they're doing. That's the question they're asking the court to decide. Michigan's list maintenance activities have proven unreasonably inadequate to identify many registrants who are deceased, some of which have been deceased for a significant number of years and have been published in newspaper death notices. The foundation was able to find copies of death notices and pictures of grave markers for individuals included on the foundation's list of likely deceased registrants. See Exhibit 3. And we don't have the exhibits here in this document, and exhibits are often dozens and dozens of pages. We're not going to be able to get into all that tonight, but they're saying this is what the exhibits will show. We're going to take that at face value. Michigan's activities for removing the names of deceased registrants from the list of eligible voters, overseen by the defendant in her capacity as the state's chief election official, are unreasonable and inadequate to meet the obligations required by the National Voter Registration Act. Defendant is not following the existing federal, state laws and procedures, and to the extent she is, her efforts are inadequate. Among the evidentiary basis for this allegation are A, the presence of significant numbers of registrants on the rolls who have been deceased for many years or even decades, and B, defendant's refusal to act despite specific information about deceased active registrants being brought to her attention. Defendant's actions and inactions in this regard constitute a clear failure to conduct reasonable list maintenance under the National Voting Rights Act. So that's a smart argument. years or even decades. I mean, that's the point. They're saying we're not just talking about people that died last year. We're talking about people that died 10, 20 years ago and still are on the voter rolls. All right, we're 7 pages down. Take a sippy break here. Thousands of deceased registrants remain on the voter rolls. Subheading, the Foundation's discovery of the problem. The defendant's failures have occurred over an extended period of time. The Foundation, in turn, has sought to remedy these failures over an extended period of time. That's good legal writing right there. The repetition, an extended period of time. We've sought to remedy these failures over an extended period of time. The Foundation first analyzed the accuracy of Michigan's voter rolls with respect to deceased registrants in early 2020 after obtaining a copy of the state's qualified voter file as of September 2019. In fact, maybe I should show you guys what a voter file looks like so you can see. Hold on one sec. I've got one, I've got a part of a voter roll from October 2019. Let me open it up here. Hold on one sec. Let's just, I'll show you what we have here. Let's see. Now, where's the history file? Okay, well, here's one. All right, so, yeah, let me change my screen share here one moment. I'm going to just bring up a different screen. Okay, this is what a typical voter roll actually looks like. You've got a voter ID number. You've got the name of the voter. That's the last name, first name, the middle name, suffix, year of birth. And by the way, I would wager the SOS has the full date of birth, but for the public records request that we get, they only give us the year. The sex, the birth date. No, this is the birth year. This is the registration date. Then we have these are address fields, I think. Let me double check. They have a few fields that are just very rarely used for addressing. Let's see if any of these have whatever this field is. They don't. Okay, it's probably, yeah, I'll tell you what I'll do. Sort by column I. Let's see here. Anyway, these are addressing fields. Okay, yeah, there's nothing in column I. So you have the address, and you've got sometimes the prefix of the street name, drive. This is all just addressing. City, state, zip. Sometimes you have a different mailing address for absentee voters, like this one's actually in Sweden. And then you've got jurisdiction information. So you've got the county, the township, the congressional district, the state house district, state senate district. That's the congressional district. That's probably the that's probably like the school district number or something. County commission district, Rochester Community Schools, the name of the school district. Then you've got this is probably the permanent absentee flag, whether or not the person's a permanent absentee voter. And then you've got voter history. You've got I must have enhanced this file because those are phone numbers. Let me try to scroll away from those. Yeah, these must be like one of our enhanced voter files that you can buy on Michigan or rescuemichigan.com. But you got voter history, and it's got how they voted, absentee or regular, and all these different elections. So that's what a voter file looks like. All right, let me go back to what we were doing here. We'll bring the lawsuit back up. Okay. So that's what a voter register, that's what the QVF looks like. The Foundation's research sampled registrants classified as active. Oh, that was a column we didn't see, but yeah, they have voters that are either one of 3 types: active, challenge, or verify. And the overwhelming majority are active. Under Michigan law, the defendant shall create an inactive voter file. A registrant appears inactive if on the voter file, if he or she was sent a notice under this law to confirm the elector's residence information, or if an elector does not vote for 6 consecutive years. And I think Benson was trying to really do away with that, because at some point they're supposed to actually be taken off the rolls. And but here we go. A registrant listed in the inactive voter file remains ineligible to vote, and his or her name must appear on the precinct voter registration list. Okay, so there you go. The foundation procured a data analytics expert to identify active status residents who are deceased in a sample study. Because the state of Michigan does not publish the full dates of birth of registrants on the QVF, and I say, as I was just saying, I think they have them, but they don't give them to us. But here they say, here's what we had to do to find out who they really were. Data analytics expert first cross-referenced the voter registration file provided by the defendant with commercial databases, e.g. credit reporting agencies and other licensed databases, to ascertain the full dates of birth. The expert also checked for evidence of commercial activity to help limit the possibility of false positives. An individual was found to have had any recent financial activity. The expert went no further in trying to determine if the individual is deceased and assumed the individual to be alive. The data analytics expert then took the sampling of active registrants with no recent commercial activity and sent the names, dates of birth, and addresses of those registrants to a federally licensed database vendor who has access to the Social Security Administration's databases. After matching Social Security numbers to registrant sample number 1, funny that your Social Security number is for sale, isn't it? The resulting list was examined against the Social Security Death Index. Identify the names of those registrants who are deceased. This process identified 34,000 potentially deceased registrants on Michigan's voter rolls. Now, to give you an idea of this number, Michigan's population has been estimated by the census. It's been 10 million people. Barely changed at all in the past 10 years. We have 10 million people in Michigan. So 34,000 is 1/3%, which, depending on how you look at it, it sounds like kind of a lot. 1/3%. And that's for, of all people, not just eligible registered voters, which is a smaller pool. So they're more than just 1/3%. It might be closer to 0.5%. In a letter dated September 18th, 2020, the foundation alerted defendant to its research and findings, including the fact that approximately 34,000 registrants appeared to be deceased. The letter also served as statutory notice to the defendant that Michigan was in violation of the National Voting Rights Act, or Voter Registration Act, see Exhibit 4, notice letter. Notice letter was sent to the defendant via USPS certified mail return receipt. According to the USPS, it was delivered, signed for. There's the exhibit establishing that Benson received the letter. They have a footnote, although extremely rare. The SSDI does occasionally include the names of individuals who have not died. The data analytics expert hired by the foundation seeks to guard against this by further comparing the names of individuals on the SSDI to obituaries and other publicly available sources of deceased individuals, e.g. credit reporting agencies. Anyone with commercial activity following a reported date of death is eliminated as well. I thought we read that already. Oh well. In response to the notice letter, the defendant asked the foundation for additional information about its methodology, which the foundation provided on October 5th, 2020. Due to the importance of this issue and the imminence of the November 2020 election, the foundation provided the defendant with a spreadsheet listing the voter ID numbers of all 34,000 registrants the foundation identified. So you saw that voter file we looked at. It's got that unique voter ID number. They said, here are exactly the 34,000 registered voters by their voter ID number that we're saying are dead and shouldn't be on your list. The foundation's efforts before the November 2020 election. As an additional effort, the foundation sought to purchase an updated copy of the QVF for the entire state from defendant's office. The request was dated September 21st, but was not acknowledged as received until the foundation sent additional correspondence on September 29th, 2020. Yeah, they're terrible about getting back to you on these things. Whenever I get a QVF copy, I just drive to Lansing, fill out the form at the Bureau of Elections office, at the SOS building. You go there, you give them the check right there. It's like $20 or something. It's not expensive. You get all that turned in right there and then. Save your time. Don't do it through the mail if you don't have to. Send someone to do it. In response to the foundation's request for expedited processing, defendant's office informed the foundation that relevant staff at the Office of the Secretary of State was only in the office on Mondays. You know, the nice thing about this suit is some of these things are good to know, good to use. I mean, this is disgraceful. 1 month before the 2020 election, the relevant staff, meaning the FOIA coordinator, was only in the office on Mondays. Absolutely unacceptable. To ensure that it received the requested data in a timely manner, And there we go. The foundation representative drove from Indianapolis to the defendant's office on October 5th to pay for and retrieve the requested data. Yeah, that's what they did. They made him drive up to Lansing to go to the Bureau of Elections to get it all done in person. What scum these people are. The foundation again hired a data analytics expert to identify deceased registrants. The foundation incurred costs based on the number of registrations examined in order to not simply duplicate prior work and in order to ascertain whether not yet identified deceased registrants are in the QVF. The foundation altered its research in 2 ways. By the way, I like that they're being so specific about exactly what they were doing. This is a well-crafted complaint. First, it requested that the data analytics expert research all individuals who were registered after October 1st, 2019, as those individuals would not have been included in the foundation's previous copy of the QVF. So they're saying, we'll get this data set and we'll isolate out the people that are new. And that way we're just looking at to see, did they remove the people we told them were dead? We also have a footnote here. In an abundance of caution regarding the potential disclosure of personally identifying information, the foundation is not attaching a copy of the spreadsheets provided to the defendant here. And what's that in reference to? Let's see, where's this footnote? The foundation provided a spreadsheet in the voter ID numbers, data, and so that they didn't include that in the attachment. This was dumb. This is dumb. First of all, these people are dead, and secondly, we're talking about public records. I mean, I just showed you guys some people's voter ID numbers. They're in the public records. They're public information. You can look up your own voter ID number if you want. Whatever. Anyway. Yeah, personally identifying information. You know, you hear sometimes in the news all these stupid stories. Russia obtained copies of the voter rolls in all 50 states. Yeah, they're public records. I got the entire Michigan qualified voter file for $20. And by the way, the voter files that we've got on rescuemichigan.com are not just those $20 voter files. No, they're enhanced from some of these data brokers we're talking about. Data analytics experts have gone through and added things like party affiliation scores and issue targets and donation history and all kinds of other stuff. But anyway, the foundation requested that the data analytics expert build a sample, eventually totaling 3.2 million registrants. That's a big sample. That sounds like all of them. With the following criteria. They registered to vote after October 1st, 2019. They are listed as inactive or CHA status, or 3, they did not show recent financial activity from credit reporting bureaus for an extended period of time leading up to the study. 3.2 million. Let that sink in. 3.2 million new registrants since October 1st, 2019. Now, some of those might be people that moved, because when you move, you basically re-register. And those count as new registrations. So some of that's happening, but that's still out of 10 million people, let alone eligible voters. That's a lot of voter registrations there. Anyway, the data analytics expert then took that list of 3.2 million registrants to a federally licensed database vendor, which has access to the Social Security Administration's database. So same company, probably Experian or Aristotle or one of them. After matching Social Security numbers to registrants, the resulting list was examined against the SSDI to identify the names of those registrants who are deceased. This process identified more than 27,500 potentially deceased registrants out of the examined subset of Michigan's QVF. The foundation alerted the defendant to these additional findings on November 25th, 2020. So we're now after Election Day. On December 11th, 2020, the foundation requested the opportunity to inspect records pursuant to the National Voter Registration Act concerning defendants' efforts to remove deceased registrants from the QVF. The foundation stated its intention to conduct the inspection on December 18th. So they said, would you mind if we looked at your efforts, show us your papers to show you what you actually did about removing the deceased? And what a surprise. After multiple attempts to reach defendant's office, the foundation received an email from her office late on December 17th, 2020, denying the foundation's request to inspect the documents. See Exhibit 10. We don't have the exhibits. I hope they cite it here. And we'll come back to the footnote in a second. In the same email, defendant's representative stated defendant's office is still awaiting your matching criteria, which was requested on September 30th, even though the foundation provided the requested information on October 5th, 2020, see Exhibit 6. Oh, we don't get to see what they said. I might have to look for the exhibits on this. Anyway, let's see what this says. To improve the confidence of its matches, the data analytics expert further... No, this is the same thing we saw last time. All right. Where were we? On December 18th, 2020, the foundation informed defendant that she was in violation of the National Voter Registration Act for failing to permit inspection and duplication of public records as required by 52 U.S.C. Yada, yada, yada. The inspection notice letter was sent to defendant via email and U.S. Postal Service certified mail return receipt. On December 18th, the foundation received an email response saying, "Thank you for contacting the office. Your message is important to me. This email confirms I have received your correspondence. Please know that my staff and I read every email and appreciate your patience as we respond to your message." This is a lie. My staff and I. That means me and my staff both read every one of your emails. Yeah, fat chance. You think Benson reads every email our office receives? Get real. And anyway, this is obviously an automated reply letter. Defendant did not respond, and also the USPS confirmed they received the letter. Defendant did not respond to the inspection notice letter. On January 13th, the foundation sent a letter to the defendant reiterating the information it provided on October 5th. The foundation, so this is now 3 months later. The foundation included a spreadsheet listing the voter registration numbers of the registrants it identified in its most recent research so that defendant could review the findings. Defendant did not respond to the correspondence at all. Next heading, defendant acknowledges pattern of list maintenance failures but does not address the foundation's concerns. On January 28th, 2021, defendant issued a press release concerning so-called ongoing voter registration list maintenance. And there's the press release cited there. Specifically, defendant references approximately 177,000 voter registrations slated for cancellation because the state has reason to believe the voter has moved away from the registration address. So after the election, she cleans up the voter rolls, right? Nowhere in this press release does defendant reference list maintenance because of the death of the registrant. There is no reason to believe that the failures identified by the foundation have been corrected. In the same press release, defendant stated, "The work we are doing now will ensure the list of registered voters, which has gone over a decade without sufficient comprehensive efforts to ensure an accuracy." That's a ribbing of Ruth Johnson right there. And yeah, if you got voters that were dead 20 years, something funny's going on. But nevertheless, the file is updated and modernized with methods to promote integrity and prevent any eligible voter from disenfranchisement. Exhibit 14 at 2. Oh, hold on, let me just double check something. All right. Upon information and belief, the work to which defendant refers are the efforts outlined in the press release regarding registrants who have moved, not any list maintenance efforts based on the death of a registrant. Even if the press release purports to address deceased registrants, the efforts were a failure. To confirm the foundation's understanding that defendant still had not corrected list maintenance efforts based on the death of the registrant in light of the January 28th, 2021 announcement, the foundation accessed the defendant's list of 177,000 voter registrations slated for cancellation and compared it against the foundation's latest sampling of approximately 27,500 potentially deceased residents. The foundation found no pattern of overlapping records to indicate that registrants within the collection of 27,500 were within the listing of 177,000 officially slated for removal. So let's be clear what they're saying here. What they're saying is, where they say they found no pattern of overlapping records, what they're saying is some segment of the 27,000 we had were maybe in the 177,000, but it would be statistically average. Like if they really made sure to try to remove those 27,000, they'd almost all be in that batch of 177,000. They're saying there's no pattern of overlapping records. So that's what they mean by that. The foundation's efforts following the November 2020 election. We're getting closer to the end, guys. So thanks for bearing with us. I know this is a little tedious to read, but this is important. This is the case that's been laid out before the District Court for Western Michigan, federal court. The foundation's efforts following the November 2020 election. To provide additional confirmation that defendant had not corrected her list maintenance failures based on the death of the registrant following the November 2020 election, the foundation purchased, for the third time, an updated QVF for the entire state of Michigan from defendant's office in March 2021. Again, to ensure that it received the requested data in a timely manner, a foundation representative drove to defendant's office to pay for and retrieve the requested data. Yeah, they learned the hard way, just like I did. The foundation then had the data analytics expert compare the list of likely deceased registrants to defendant in November 2020 against the March 2021 QVF file. And once again, they did not. Oh, wait, let's see here. Okay. The foundation did so to ascertain whether any individuals previously identified by the foundation as deceased had since been removed. The foundation did not expand its research to ascertain whether additional registrants were deceased. So they're saying there might have even still been more. But we just want to look at the people that we told her had died. Of the 25,000 people we identified, how many of them are still on this list? As a result of this analysis, the foundation confirmed that all, that should have been in like bold, underline, italic, dash repeat, all of the more than 27,500 potentially deceased registrants previously identified out of the examined subset of Michigan's QVF remained on the rolls as of March 1st, 2021. Then, in August 2021, the foundation, by the way, keep in mind now, Benson, I mean, they've already sued the city of Detroit. They've been corresponding with Benson the whole past couple years. Then in August 2021, the foundation, for the fourth time, purchased an updated copy of Michigan's QVF to verify its previous research. Oh, also, by the way, they're talking about, I was joking about the fact they had to drive to Lansing to get the voter file, but what they're actually doing here is establishing that there was costs involved, there was time involved, there was resources involved to do this. They're trying to make an argument that we have faced financial setbacks having to go through all this. That's why these things are in there. They're not just putting in those to rib Benson. They're putting them in there to show that we have lost money doing this. We have a financial loss. We've had a resources loss. But they say then in August 2021, for the fourth time, purchase an updated copy. As before, they did data analytics, and again, they didn't expand to ascertain whether additional registrants were dead. As a result of the analysis, the foundation confirmed that 25,975, or 94% of the more than 27,500 potentially deceased residents previously identified the examined subset of the QVF, remained on the rolls as of August 5th, 2021. The 25,975 consisted of 24,645 active registrants, meaning have voted in one of the last 6 elections, and 1,330 inactive or CHA, challenge registrants. Numerous registrants have voter registration dates after their reported date of their death. The foundation's August 2021 analysis also identified registrations where dates of death per the SSDI preceded dates of registration as shown in the official QVF extract. These sequence conflicts are distributed throughout time and do not appear to heighten at any particular point. The August 2021 analysis ultimately found 334 registration records established after death, 15 that occurred in the year 2020. Without further inquiry, there is no way to know for certain whether these post-death registrations are the result of identity theft, data input error, or some other reason. But this kind of issue would not arise if Michigan cross-referenced new registrations with the Social Security Death Index. With such a high prevalence of apparent post-death registrations, it is only reasonable to incorporate and unreasonable to not incorporate SSDI cross-references in the registration process. And again, remember, they're making the argument that what she's doing, her efforts are not reasonable. That's why they keep reiterating this. The foundation's filing, let me see. Oh, there's a footnote here. Let me see if we went past it already. Here we go. Or some other reason. The footnote says, Michigan, like many other states, employs a system of inserting fictitious or placeholder dates into the qualified voter file. A standardized date of 1/1/1900 can be seen within the date of registration field when the actual date is not kept on record. Within the 25,975 deceased list from August 2021, over 2,000 show placeholder dates of registration. No registrants showing placeholder data were counted in the sequence conflict total. Okay. Anyway, the foundation's findings merit investigation and action by the defendant. Litigation brought by the foundation in Pennsylvania shortly before the 2020 general election revealed more than 100 instances of the same sequence conflict. In early 2021, a Pennsylvania widower was indicted for allegedly impersonating his wife by registering to vote after she died and requesting an absentee ballot. The deceased wife appears on the foundation's list of active registrants provided to Pennsylvania. The man is accused of impersonating his dead wife in the final days of the 2020 election. Despite her death in 2013, the deceased was credited for voting absentee in the 2020 general election. So they're giving an example of why they want to find out this information. Defendant cannot justify her failures by pointing to a state statute or practice delegating to local officials the responsibility for removing deceased registrants from the voter rolls. Under the National Voter Registration Act, it is the obligation of Jocelyn Benson to conduct a reasonable program to remove the names of deceased registrants from the state's list of eligible registrants. Defendant has failed to fulfill her legal requirement in this regard, and she cannot avoid her culpability by citing to state law or procedures that might allegedly complicate her task or seek to thrust the duties assigned to her under federal law to one or more third parties. So they're preemptively attacking what she's going to claim in response. Oh, that's not my job. That's the local official's job. Oh, I'm so busy. I'm so busy doing other stuff that the state makes me do. No, can't do that. Further, defendant's obligation to maintain accurate voter rolls necessitates that accurate data has been entered. For example, if the date of birth has been entered incorrectly, then any list maintenance attempted thereafter cannot be effective. Having a process in place that systematically removes deceased registrants is not just a good idea, it is the law. The foundation to be able to identify more than 25,000 deceased registrants on a conservative sample of the QVF it examined. Wow. The citation needed. I want to know what the sampling was. What sample out of 10 million? Because like I said, 25,000 is 0.25% of the entire thing. What's your sample size? If it's 10%, now we're talking not 0.25%. Now we're talking 2.5%. That's huge. And for defendant to fail to act upon the information provided by the foundation over the course of many months, I like it, demonstrates emphatically that Michigan has failed to reasonably implement and or conduct a systematic list maintenance program that complies with federal law requiring deceased electors to be removed from the voter rolls. The National Voter Registration Act's requirement that each state make any reasonable effort to remove the names of deceased registrants from their list of eligible voters also necessitates the state consider and act upon credible data from sources outside its normal procedures, including but not limited to the SSDI refined information provided by the foundation. What's this footnote here? The guy that voted in Pennsylvania after for his dead wife. South Park man. Oh, that's South Park. South Park man charged with casting ballot in dead wife's name. Oh, good. He was charged. Good. But anyway, plaintiff's statutory right to bring this action under the National Voter Registration Act. The foundation is entitled to bring this civil action pursuant to section yada yada because the foundation provided statutory notice to the defendant, the chief election official, that Michigan was in violation of the NVRA. See Exhibits 4 through 11. Following the 4 and 11. Following the receipt of the foundation's formal notice letter, the defendant failed to timely correct the violations by conducting reasonable list maintenance to ensure the deceased registrants were timely removed from Michigan voter rolls. So count 1, violation of the NVRA, failure to conduct list maintenance, all the stuff we said above, failed to make reasonable, and this is going to be repetitive. Failed to make reasonable efforts, had not been corrected within 20 days of the notice of the violation. And it says the violation is not corrected within 20 days after receipt of the notice. If the violation occurred within 120 days before the date of election, the aggrieved person may bring a civil action. So there it is. Defendant's list maintenance programs and activities have demonstrably failed to remove many thousands of long deceased registrants from the state's list of eligible registrants. Whatever efforts are being made by the defendant, they are unreasonable within the meaning of the NVRA because they are demonstrably not working. The National Voter Registration Act does not simply require a percentage or a portion of dead registrants to be removed. It requires a program that actually reasonably detects dead registrants and removes them. When more than 25,000 deceased registrants are identified on the QVF and are not removed for an extended period of years, the list maintenance program is not only unreasonable, it is failing. The foundation has suffered an irreparable injury as a direct result of defendant's violation of Section 8. Defendant's failure to comply with the NVRA has aggrieved and continues to aggrieve the foundation by impairing its essential and core mission of fostering compliance with federal election laws and promoting election integrity. Defendant's failure to comply with the NVRA has caused and continues to cause the foundation pecuniary injury. I think that means money. Perceptively impairs the foundation's mission and frustrates the organization's purposes. The foundation has no adequate remedy at law. Meaning they're saying we were financially harmed. This bit here, I think, is going to be the toughest part, because the questions are going to be, how much did it cost you? What was the real damages? What happened? Did you do anything that might have mitigated the damages? If so, what was the result of that? Like, you sent out a fundraising letter. Hey, everybody, you wouldn't believe what's going on in Michigan. We need more support to be able to do more things in other states. And if you raise money off a fundraising letter like that, they might say, well, you haven't gotten that damage. Benson's going to attack this first. If there's anything that's weak in their case, it's their standing based on their injuries. That's the challenge they're going to have to overcome. Count 2, violation of the National Voter Registration Act, failure to allow inspection of records and data. Defendant has failed to allow the foundation to inspect records concerning the implementation of programs and activities in violation of Section 8. This one's probably pretty solid, because as we read, they said, we need to see your stuff, and she never responded. Defendant's failure has not been corrected within 90 days of the foundation's notice of the violation. And they cite it's been more than, if not done in 90 days, you can bring a civil action, which is what they did. The foundation has suffered an informational injury as a direct result of defendant's violations of Section 8 because the foundation does not have the data and records requested. The NVRA confers upon the foundation a right to information. And by denying that information to the foundation, the defendants have caused a concrete injury to the plaintiff. This violation also prevents the foundation from engaging in its research, educational, and remedial activities. The foundation will continue to be injured by defendants' violations of Section 8 and the National Voter Registration Act, unless and until defendant is enjoined from continuing to violate the law. So, prayer for relief, they're asking for a judgment declaring Jocelyn Benson to be in violation of the National Voter Registration Act, ordering Jocelyn Benson to immediately and thoroughly investigate the deceased registrants identified by the foundation and remove confirmed deceased registrants from the QVF, ordering Jocelyn Benson to allow inspection of records concerning the implementation of programs and activities for the purpose of ensuring the accuracy of currency of Michigan's official lists, ordering defendant to implement and follow a reasonable and effective list maintenance program to cure the violations identified herein and bring the state's voter rolls into compliance with Section 8 of the NVRA, ordering the defendant to cross-reference the names of new registrants against the SSDI, ordering the plaintiff to pay the foundation's reasonable attorney's fees, including litigation expenses and costs, and granting the foundation such further relief as the court deems proper, including all other injunctive relief available to the court. Injunctive relief means telling someone to do something or not to do something. So that's the lawsuit. That is the Public Interest Legal Foundation's lawsuit, minus the exhibits. So some thoughts on this. The facts are all well argued. And again, we don't have the exhibits, but assuming the exhibits all bear out what they say, which they, really, really likely should, this is a strong looking case. And certainly these are allegations that people should be talking about. The challenge for the Public Interest Legal Foundation is Benson's going to claim, most likely her argument's going to be that what she did was reasonable in the circumstances, and or that I think front and center they're going to say they've not established sufficient harm. Whether or not a federal judge agrees with that, look, I'm not a lawyer. They've argued that she has an obligation to do things. They've noted the federal law that says she has an obligation to do these things. She's not doing them. I should at least compel injunctive relief. But, in courts, a lot of things can depend on judges, and judges have done some absolutely ridiculous, stupid things over the years. So who knows? Who knows where this goes? We'll be watching. We'll cover it when Benson responds. We'll see what she says. We'll see what her arguments are. We'll see if they match what I predict they are. She may also have some other side of the story as to receiving these people's correspondence. So, yeah. If I can find the exhibits and there's anything interesting in them, like anything, like, for example, They mentioned it near the top. Some of these have been dead for 20 years, 10 years, 5 years, and thousands of all of them. I'd like to know who they are. I would like to see those, because we have and give out voter files to people. I want to know the voter ID numbers of the people that are dead. I might contact these people tomorrow and ask them if they can share it with me. Don't see why they wouldn't. Anyway, this is a really interesting case, and we'll see where it goes. Because if it does move forward, even if it only gets to discovery, this is a really bad look for Jocelyn Benson. The media won't cover it, but you on the grassroots can. You can tell people. You can tell your neighbors. You can tell people in your precinct, especially next year when the election's coming up. Jocelyn Benson deliberately refused to remove dead voters from their rolls. So there you go, guys. That is the lawsuit. And we've been going for more than an hour, so I'm going to call this a stream. If you like this kind of content, be sure you like, share, subscribe. If you're on YouTube, subscribe on Rumble. If you're on Rumble, subscribe on YouTube. So when you go to YouTube sometime watching somebody else, you might see one of our videos, and remember to go back to Rumble. And of course, check out rescuemichigan.com, where we've got all kinds of information on election stuff, on lockdown issues, freedom issues, legislative alerts, all kinds of things. And yeah, if you like this kind of stuff, make sure you tune in, because we're going to be doing a lot more of this content in the months to come. And as always, thanks for all that you guys do for liberty. So until next time, peace.